This program is brought to you by the Georgia Neurosurgical Institute. For over 50 years, rendering neurosurgical care to patients of all social conditions, treating complicated problems involving the brain, spine, spinal cord, and peripheral nerves, endeavoring to encourage quality care, medical research, innovation, and education on a local, national, and international basis.
Robinson. It's my pleasure to have with us tonight Mr. Buck Melton. Welcome, Buck. You've been here a lot.
Yes.
We have, I think, an interesting conversation tonight.
A lot to talk about this week.
But before we get into that, if I can make a little jokey comment here. You know, there's been a lot of attention. Everyone is running for president.
Could it be?
Right. No, many people are running for president. I think there's 16 or 17 candidates out there.
Are you going to be our 18th?
No, I'd like to remove all speculation that I've elected.
This is it, folks.
I've elected not to run for president, so there we go. You know, we already have one neurosurgeon whose hat's in the ring, Dr. Ben Carson, so one's enough, but I thought I just needed to make that announcement.
You have just disappointed all
well,
of our
I know
loyal
that,
viewers and TV
I know that
members.
well. I guess we just have to deal with it. Well, after my little jokey comment, maybe we can discuss some of the important issues that confront our world today. And I know you're a constitutional scholar and an expert on the Supreme Court, and the court's opined on many important issues recently. But maybe we could spend a little time talking about some of the decisions they've made in the past that many observers would question these days. They'd wonder how the Supreme Court came up with a logic that led them into what contemporary people would say would be error. And possibly we could start by talking about the Dred Scott decision. Do you have any comments about that?
Yes, the infamous Dred Scott case, the most infamous case that the Supreme Court has probably ever decided. And there are several reasons why that case is so notorious. The court decided it in 1857. The specific question was essentially if a slave were taken into federal territory where Congress had banned slavery, did he thereby become free? And the Supreme Court, a horribly divided Supreme Court, answered not only did he not become free, but that Congress did not have any power to ban slavery in the federal territories. And Chief Justice Roger Taney wrote the very
a South Carolinian?
Marylander.
Maryland,
actually.
okay.
Still technically Southern,
right,
but not.
Yes.
Maryland is not
Roger,
quite Southern.
Okay, yes.
But Taney is a very famous name in Maryland, and he wrote the very notorious remark that all of American history up to that point showed that the black man had no rights that the white man was bound to respect. And you can imagine the firestorm that caused.
Was this a 5-4 decision or something like that?
I think it was probably I don't even think you can do it 5-4. I think every justice wrote his own opinion.
Oh, really? So yes.
Yes, but it was sharply divided.
Right, yes.
And this actually became one of the fuses that led to the Civil War. The
Yes.
Lincoln-Douglas debates of the following year focused very heavily on whether or not the Dred Scott decision had been properly decided, whether or not it was right. And Stephen A. Douglas, the Democratic candidate, was trying to appeal both to the northern and southern wings of the Democratic Party and trying to walk a tightrope, saying, well, yes, it's the law of the land and it's a decision, but just because the Supreme Court has ruled this way doesn't mean that the territorial legislatures have to be friendly to slavery. A very contorted answer. And go ahead.
Now, in this situation, just looking at when the Supreme Court opines like this,
Yes.
I mean, and suppose you lived in 1857, the only way to go around this decision would be a constitutional amendment. Is that correct?
Yes.
So once the Supreme Court speaks, then it's really impossible to do anything other than to change the Constitution.
If the court speaks broadly enough, yes. And this is one of the very few occasions when you in fact do see the Supreme Court decision being overruled by a constitutional amendment. The first words of the 14th Amendment spoke specifically to Dred Scott in saying that all persons born or naturalized in the United States are citizens. So that was a direct overturning and refutation of Taney's infamous sentence.
And this took a civil war to do this.
It
so
did,
I
yes.
mentioned maybe you could have a constitutional amendment. Another way to change the law is to have a civil war. But that was they're very the power of the Supreme Court in these circumstances is enormous, is it not? And
it is.
And so just to discuss this situation, this is a case. I mean, we mentioned this earlier in our private conversations about law and morality. So presumably, just looking at this arrangement, you could say that Taney's decision, in a way, he might consider that, if you really question him about it, kind of a moral viewpoint. I mean, and it sounds strange to say that,
yes.
but I mean, if you really, since this was kind of, in some ways, an extra legal decision, is that a fair statement? I mean, was there legal backing for this kind of opinion?
Well, the thing that Taney probably engaged in was, it was outcome driven. Some of the older viewers out there may remember Ed Wilson, former mayor of Macon, law professor. And he once made the point that a lot of judges, when they're presented with an issue in a case, they start by asking what ought the outcome to be? What is the fair and just and right outcome in this case? And then once they've decided that, then they look up legal arguments to support it. And that can be subjected to very, very heavy criticism. Justice Scalia has actually said that if you do this, then you're right practically every time in your constitutional interpretation. If you start out by saying, what ought the Constitution to mean, then you're going to be right in your own eyes a vast majority of the time. And it's really an affirming thing. It makes you feel good about yourself, but it may not be the law.
I don't want to put too fine of a point on this, but just the first thing is maybe the power of the Supreme
yes.
Court under these circumstances is enormous. There's a tremendous power in really setting the direction of the country, and many times the direction they take is certainly causes a lot of tension, to put it mildly. But the idea that you can actually have sort of an outcome-driven decision, do we really need lawyers to do that?
Not
so
at
in
all.
other words, if you're there and you just have lay people that are on there, or anybody, you could have people that represented different moral groups in the country. I mean, I could have someone from, I don't know, Islamic person, or you could have a person that was, I don't know, an atheist, just different kinds of viewpoints, and they would not have to have any legal training. And they could just, on every single case that came along, they'd say, what's the issue here? Well, is slavery in these federal territories? Well, property rights trump everything. There's nothing any more powerful than a property right.
Well, except liberty, but we'll
well,
get
no,
into
no.
that
But
later.
what I'm saying, no.
Somebody could say
no.
this.
What I'm
hypothetically,
making
yes.
the comment that in 1857, we have these different kind of, I guess, concepts competing with one another. And the idea that property, just this tremendous, huge thing that the courts had to respect, and slaves were property, ergo, this would be sort of theft of property. And it was the way that it's like your yacht was stolen, and your yacht went somewhere, and no matter what the federal government said about it, your right to property trumped everything.
And that was very much what Taney was saying, as a matter of fact. And we see this idea that morality or justice is subjective in a lot of ways recently, when Justice Sotomayor was nominated to the Supreme Court bench.
Yes.
Obviously, we went back into her background, and it was revealed that at one point she was talking about how she believed that a wise Latina could bring more justice to the court than others. Well, if justice is objective and absolute, it doesn't matter if it's a Latina or not. It should be completely irrelevant. So the fact that she was suggesting that a wise Latina's idea of justice was going to be different from an atheist or a white Protestant or what have you, it's very, very disturbing.
Well, I mean, just to go back to sort of on this subject, the idea that we don't really need lawyers.
Correct.
To if this is the and to go to Justice Sotomayor's comment, really you don't need there doesn't need to be a JD degree attached to the wise person. You could presumably just have people almost chosen at random and say, what do you, like a jury pool kind of, in the Supreme Court, and the facts could be presented to this, all kinds of systems are possible to reflect the general view of morality. So if precedent has nothing to do with anything, and you have these very intelligent law clerks at your very smart guys, you could say, go in there and extract defense of property.
Yes.
I mean, all right, I want to do something in defense of slavery, says a person. Go in the Constitution and find some way to do that.
Yes.
Because property rights they're more important than anything. So probably there's some statement in the Constitution about protecting property somewhere.
Yes.
So that's the and these other ideas are in there as well. But you could just say, well, in my opinion, it's the property rights are in the national interest, and on. If you don't have property rights, and so if you take my point, the system is really sort of careening a bit as it did in 1857. Maybe we can keep at that how the Supreme Court, you could say, fell in error. Mm-hmm. Was there, just to ask this question, was there on the other side, did law support the idea in any way that Dred Scott should have been freed when he went into the free territories? I mean, besides morality.
Well, yes, there were arguments to be made. We always have to remember that, today, and obviously things have changed since Dred Scott, but some things have remained the same, in that it takes a great deal of money, on the order of millions of dollars, to litigate most cases to the Supreme Court. And therefore, you are not going to shell out that kind of money in support of your cause unless you think you've got a darn good case. And the Supreme Court's probably not even going to hear it unless it thinks that there are merits on both sides of the issue. So yes, usually when a case gets to the Supreme Court or even to a federal court of appeals, there are serious arguments on both sides. There were serious arguments on the side of the slave Dred Scott. The court, in the end, for whatever reason, and tonight we are suspecting that those reasons had nothing to do with the law, but everything to do with personal preference, those arguments that Dred Scott had did not have sufficient merit.
Now, going back to the Justice Sotomayor's comments here,
I'm going
to give that a little comment. If you look at the people that were on the Supreme Court at that time,
yes.
I mean, I don't know how many people owned slaves. Presumably, maybe Justice Taney did. But
7 white men, 2 or 3 of them were slave owners.
Well, so if you were a slave owner, should you have abstained from decision making on this? I mean, shouldn't that have happened? And really, what I'm getting at is there are no people of color on the Supreme Court in 1857. I mean, they're all property owners, and there are a number of slave owners. So you had a very selected group of people passing an opinion that a great amount of the population had no access to this part of the arrangement.
And this is where you can't dismiss Sotomayor's comment out of hand, because obviously had there been persons of color on that court, you would have gotten a different result. So perhaps to some degree the concept of justice is malleable. C.S. Lewis once pointed out that all societies throughout history have seen cowardice as a bad thing. I think that's as close to universal as you can get. But how cowardice is portrayed or displayed can differ from culture to culture. For instance, it is cowardice under the code of Bushido to surrender. It can be seen as cowardice in some occasions in Western culture to kill yourself. So they have different concepts of what constitutes cowardice.
Yes.
But we all agree that cowardice is bad.
Yes. Well, now, so this decision, you could make the case that maybe there was not all opinions were put there. The decision was you couldn't do anything about it after it happened. It set the nation on a very difficult course. Now, has the Supreme Court done other things that are of comparable, gravity?
Yes. Well, one of the most denounced cases, other than Dred Scott, would be Lochner versus New York, decided, I believe it was 1905, certainly the first few years of the 20th century. And this was a time when labor unions were trying to get some traction, when you started to see a lot of disparity between the rich and the poor, when there were no labor laws, when working conditions were horrible. And New York's bakers were normally, it was a buyer's market for employers, and they were able to work bakers in terrible conditions, 10 or 12 hours a day for 6 days a week at no minimum wage. They'd get white lung from the flour, just all sorts of horribles. New York passed a law essentially allowing bakers to join unions. This is an oversimplification. The bakery owners took that all the way to the Supreme Court, and the Supreme Court, in looking at the due process clause, that the government cannot deprive someone of life, liberty, or property without due process of law, said that this New York law allowing bakers to join unions violated the baker's liberty of contract. That if the bakers wished to contract to work 12 hours a day, 6 days a week, then they had the liberty to do that, and the state had no business sticking its nose into the relationship between the baker and his employer. Now, obviously, the bakers were begging the state to interfere in their liberty. They were, but the court adopted a very laissez-faire, free market-oriented, social Darwinistic view of labor. And once again, if you read the case, there's a very strong indication that they started with this approach of market capitalism and then looked up the law to support that. And in doing so, they created a constitutional right that just didn't exist. It didn't have any basis for existence. They wrote a right into the Constitution that they wanted to be there.
To basically protect property. I mean, so and we talked about property a little bit earlier. Now, there are a lot of things that are good about property. All kinds of things are good about property. If you say there could be a connection between property and liberty, if you presumably have some property, you're able to be independent from other people. You could resist a tyranny. You wouldn't be dependent on the government. So you have a lot of, presumably you have a lot of abilities to independently decide what's right and wrong, which maybe that's the system we'd like to have.
Property can mean stability.
A lot of good things attached to property. But traditionally, isn't this one of the things that's taken place with the courts in general? For a long time, the courts tilted so heavily toward defense of property, and the people that would be judges, if you looked at their background, they would be people that might have had a corporate practice. They would have clients who were very wealthy. They would have trafficked in protection of property for their whole career. I mean, is that a comment about 1905 about the judges?
I think that down until, and you can almost pinpoint the year, 1938, not all the time, but very heavily throughout its history, the court, which consisted entirely of well-to-do white men up until that point, tended to be biased in the favor of property. And the Lochner case is an example of that.
And so in some ways, I mean, I like to use this analogy. It's sort of like a zero-sum game. We're in this sort of a contained sphere, and there are balloons in there, and they have the property balloon is blown up, and in some ways, you can make the case other balloons have to be diminished, and you could say European cultural values, whatever that balloon is blown up, and if it's diminished, we're having this different kind of zero-sum game. And the courts are impacting that sort of thing. Well, now, just to go back to so I think what we're talking about is that what should the different judicial philosophies, but is there, I guess, one philosophy, the Bork philosophy, possibly the idea that what the courts do is they read the Constitution and they read the precedents, and they then give some kind of narrow opinion based on that interpretation. Is that a fair? They don't put morality into the situation exactly. They try and stay with a legal framework.
Right, and this is the difference between what we might call judicial activism and judicial restraint. And judicial restraint means consciously trying to put as little of yourself into the opinion as you can. Now, can you ever put nothing of yourself? Probably not. but limit yourself to what the law says or can be reasonably interpreted to say or mean, versus what do I want to happen, and inserting myself and my wants and desires into the case very heavily, and then making sure the case comes out that way. And I would like to say also
Yes.
that this idea of activism, putting myself into the case, can be either liberal activism
Sure,
or conservative
yes,
activism.
yes.
The Lochner case is a prime example of heavy conservative activism.
Yes.
So it's not synonymous with liberal.
Now, we've had a discussion in the past about the Constitution, and the initial sort of framers of the Constitution envisioned the idea that if it needed to be corrected, and they expected it to be corrected, and indeed, I mean, the history of the country is a quarter millennium, more or less. We have this tremendous amount of time and space that passed, and our forefathers said, well, of course the circumstances are going to change, and of course you're going to have to change the Constitution, and this is the way you do it. But it appears that it's such a contentious world out there, it's not easily changeable, and the justices have decided to do it themselves. And we talked about the Dred Scott decision. That was really the equivalent of a judicial constitutional amendment. Is that a fair statement? And the Supreme Court so they could put in judicial constitutional amendments that would almost be impossible to be overturned except with a change of the Constitution, which hardly ever happened. So can one say, can you look at the judgments of the Supreme Court and say, well, here, I don't know, 58 amendments to the American Constitution that the Supreme Court has propagated?
Yes. I'm not sure that I would call it a constitutional amendment, although I take your meaning. I would say that the court does bring about incremental constitutional change, and furthermore that it is supposed to bring about incremental constitutional change. The formal written Constitution was deliberately designed not to be easily changeable. So the court does have the job of helping the Constitution, if you will, get with the times. And this is the important part of my sentence, to a degree. Now, the court occasionally goes a lot farther than just incremental. You could say that it's revolutionary. And you see that to a degree in Dred Scott, you see it to a degree in Lochner. You can name several big cases where that happens. So the question is, if we're going to have a big change in the way we view the economic underpinnings of America or the social underpinnings of how our country works, who should be making that decision? Should it be 5 out of 9 justices, or should it be the voters? And when you phrase it that way, then you start asking, should 5 unelected people not responsible to the electorate be able to make such a quantum leap forward? Were they supposed to be able to make such a quantum leap forward?
Well, now, in the decisions we've discussed, one of the things that happened was these you could say were arch conservative decisions, and the activist judges overturned legislative legislative decisions. They overturned that. Is there some kind of, these recent Supreme Court decisions, particularly Justice Roberts, is there a symmetry in what he's doing, and that he basically is not going to overturn any of the legislative decisions? The court's going to be loath to do that. So whatever the legislature does, the courts just would say, at least a conservative on the court would say, good or bad, I'm going to be loath to ever interfere with the wisdom of the legislature.
Well, Roberts, you've chosen a very interesting and frankly a vexed case, because if you look at what Roberts has done in the 2 main Obamacare cases, it seems to me beyond question that he decided ahead of time that he wanted to make sure that the Affordable Care Act survived and was as vigorous as possible, and then went through just agonizing contortions of legal logic to try to bring that about. And then in the very next day, in the same-sex marriage case, or the very next weekday at least, well, no, it came out on Friday, the very next day, he ironically, and I believe hypocritically, said it is not the role of the courts to make the law, when he had just signed on to a decision the day before doing precisely that. So in one case you're talking about property and redistribution of wealth, taxing one
Yes.
section of America and giving tax credits to another. And in another, you're talking a broad sweeping social policy.
Yes.
So maybe that is the explanation. But I really think that Roberts is talking out of both sides of his mouth.
The Supreme Court often either affirms or, I guess, changes legislative and federal government actions. Another sort of case that's on my mind is with the, I guess, the putting Japanese American citizens in basically concentration camps in the start of World War II. The fact the Supreme Court sort of went along with that. You have any comments about that, about how that transpired?
I would say that's a little different situation. I'm obviously not supporting it, but of course I have the leisure here in a society that is at peace
Yes.
To be able to do that. When you are at war, and the two gravest wars in our history, not counting the War
Yes.
for Independence, were the Civil War and World War II.
Yes.
Because you're actually talking about national survival in those wars. Civil liberties tend to take it on the chin
Yes.
during wartime, and the court often is complicit in that. The court will not always, but often look the other way when that happens. And in the Japanese relocation cases, the court did exactly that. Sorry, but we're fighting for our lives here, and we're just going to be that way. So in another case, the Duncan case of 1944, I believe, you had a similar situation when the court pretty much allowed untrammeled martial law to take place in Hawaii. Now, after the war is over, the court will usually back off very quickly on that and hem and haw a little bit. But even so, it leaves a bad taste in our mouths.
Well, I guess sort of one reason to sort of go through this conversation, I think, is the Supreme Court is making these decisions. And in some ways, I guess the man on the street often thinks of this as sort of the Wizard of Oz arrangement.
Yes.
That there's these guys or ladies are the brightest, the wisest people in the country, and they've been pre-selected they've been chosen almost by divine right.
Yes.
Anoint's the good thing, almost a divine right kind of thing. They've been vetted, they've been chosen to be the people most interested in justice in the country. And when you put those people in the same room, they're going to come up with a decision that could be considered a just decision. And whatever that decision is, people need to pretty much acquiesce to it because of this Wizard of Oz kind of arrangement. But people that look in, as you've done in your life, look into the interstices of what goes on there, it's not so simple, is it?
Well, it's actually disturbing, and especially since some of these justices come either straight from the academy or have had a huge dose of that. Elena Kagan is an example, I believe, who had never held a judicial position in her life. And in law school, you play these academic games that you try to get as esoteric as possible. And if you do that too much, you get out of touch with the real world. It's a good thing to be able to see what the man on the street might not see, but to become so esoteric that you work a revolution that is imposed on the man on the street, regardless of what he may or may not vote for, then we start to have a problem.
Well, Bucky, this has been a good interchange tonight. We'll talk some more about
Indeed.
the Supreme Court and other things. Thank you so much for
Thank you, sir.
coming. Thank you.
This program is brought to you by the Georgia Neurosurgical Institute. For over 50 years, rendering neurosurgical care to patients of all social conditions, treating complicated problems involving the brain, spine, spinal cord, and peripheral nerves, endeavoring to encourage quality care, medical research, innovation, and education on a local, national, and international basis.